Good afternoon, Judge Allie.
Good afternoon.
How are you?
I'm well, thank you.
Thank you. Okay. I just want to place on record before we start that you and I served on the Judicial Conduct Committee for a time, Judicial Conduct Committee of the JSC, which is a subcommittee of the JSC.
That's
correct?
That is correct.
That is right. You are a judge in the Western Cape High Court.
That is so.
And for how long have you been a judge of the Western Cape?
12 years and 4 months.
12 years and 4 months.
That's right.
That's a long time. You must know, therefore, the division very well.
Yes, I do.
What can you tell us about the division that needs improvement, things that are done very well in that division so that other JPs can also hear about it?
Yes. Our division, the Western Cape division, was one of the divisions that actually started case flow management before the structures that are now in existence, in fact, existed. We started initially with pre-trials in RAF matters, road accident fund matters, and later we expanded that to pre-trials in civil matters. We have also had a joint working committee, which the judge president headed up, in which he met regularly with all the stakeholders in the province, including the heads of the district court and the heads of the regional court, and the National Prosecuting Authority, Legal Aid South Africa, and other stakeholders. So we are very gratified to see that the structures that are now in existence, such as the PEEC and the NEEC, is in fact a continuation of what we in the Western Cape had implemented several years ago. But as you correctly point out, there's always room for improvement. There are areas in pre-trials and case flow management which we can still streamline. Regrettably, we still are confronted with situations, despite our best efforts, where often on the day of trial, people or litigants seek a postponement because they want to exchange documents that were not discovered on the last minute, or they seek to have documents discovered. So there's still room for further improvement. We still can streamline case flow management. But certainly we are very gratified in the Western Cape High Court by the structures that have been put into existence, because they do, for us, it is in fact a continuation and a tightening and a more efficient way of continuing with case flow management. And ultimately, we all have the same objective, which really is to create efficiency and enhancement of the judicial administration, and so that we can, in fact, unblock the log jams. And at present, with regard to our civil role, there is now only a 6-week waiting period for allocation of trial dates or opposed motions. For us, that is good, but there's still room for improvement.
So case flow management does work?
It does work, indeed.
Yes. I'm sure you have seen the Deputy Judge President of the Western Cape. Has she retired, or is she about to retire?
She's retiring effectively at the end of this recess, which is the 17th of April this year. So as we speak, she still remains the Deputy Judge President for a few more days.
Having observed her, what, in your view or your knowledge, are the responsibilities of a Deputy Judge President?
The responsibilities that I've observed her engaged in certainly included, she assisted the Judge President with regard to allocation of files, not necessarily every day, but on an as they need basis. She also was quite involved with the setting up of the case flow management model, which we implemented prior to the PEEC and the NEEC being in existence. She, in fact, did a lot of the road accident fund pre-trials herself. So she was very hands-on in streamlining those procedures. She also did the allocation of petitions. We receive petitions, so that she does. She does the allocation of petitions. She assists largely with the allocation of full benches. She's basically the go-to person in the absence of the judge president, but she also obviously works in consultation with the judge president. So obviously from time to time there may be a need for her to deputize on his behalf and chair our weekly staff judges meetings if he is not available. She is involved with meetings with other role players as well, with the National Prosecuting Authority, with the lower court administration. And ultimately, she plays a role also with regard to meeting with the profession, the legal profession, both the bar and the side bar. And she was chair of the practice committee. We have a practice committee which deals with practice notes, practice directions and the like. She was chair of that committee right up until sometime last year, where she handed the chair of that committee over to me. So I've been working with her in taking over the practice committee and seeing what her duties and functions were there. Yes.
So if you were to be appointed as Deputy Judge President, you know those duties of the Deputy Judge President?
Yes, indeed. And of course, I would work in close collaboration with the Judge President to the extent that I may not know any of them.
Having said that, what is the relationship like between you and the judges of the Western Cape Division? I'm not going to ask between you and the Judge President.
Yes. I have a collegial and amicable relationship with the judges in the division. I work closely with a number of them, obviously by virtue of the fact that I have been around for almost 12 and a half years. I've had occasion to sit in appeals with most of them. I've had no difficulty working with them. I also, as I've indicated, serve on the practice committee, so I work with a number of my colleagues there, and I work effectively with them. I also serve on the library committee. I work with colleagues there, and we have regular weekly meetings with judges where often we work in ad hoc committees. I've been able to work collegially with people there as well.
Yes. As you know, now and again, or let's say after 4 years, or cycle of 4 years, the Judge President might go on leave, or long leave, and the responsibilities of the Judge President will fall upon you as the deputy. Am I correct?
That's correct.
Are there any challenges in that division? For example, questions of late delivery of judgments and so forth?
We have had a practice going for as long as I've been on the bench. And I acted for at least 3 years prior to me becoming, I acted 3 years prior to me becoming a permanent judge. So I would say from the year 2000, when I first acted at the High Court, and then obviously when I was there permanently from the year 2004, the Western Cape High Court has always had a situation where reserved judgments are noted on a list, which with the time was circulated to the profession, both the bar and the side bar, as well as to the judges in the division. So it had the effect of some peer pressure being put on colleagues, because obviously, in a sense, they were named and shamed because their names would appear on a list. And we had a practice going then, before, of course, the existence of the regulations that we now have, where judgments ought to be delivered, reserved judgments ought to be delivered within a period of 3 months. Way back then, we already had a practice whereby we would deliver reserved judgments at the end of the term in which they were reserved, alternatively early in the following term. So that difficulty hasn't been a major difficulty, but my style of management in the committees and generally dealing with colleagues is one of consultation. So I would always consult with colleagues first and see where there are difficulties, if any. If I were to be Deputy Judge President and we have colleagues who are not delivering judgments within the three-month period from the date of it being reserved, my style would be to first consult and establish what difficulties, if any, they are experiencing. And if, for example, it is a situation where they're simply overloaded with work, our Judge President has always had this policy, and I would support him in that, is that if colleagues approach the Judge President and say that, look, we have too many reserves, we're a little snowed under, can you give us some leeway and just for 2 days or 3 days not allocate any work to us? I would have no difficulty in continuing to implement such a practice but obviously each case would have to be decided on its merits. I mean, there would have to be value or there would have to be some truth to the fact that the colleague or the allegation that the colleague is in fact really overloaded with work. But there are certainly mechanisms that one can put in place to have the colleague deliver the judgment more speedily. And of course, if all of that fails in any event, now with norms and standards and with the need or the imperative on colleagues to deliver their judgments within 3 months, it would go to the Office of the Chief Justice anyway. And having served on the Judicial Conduct Committee, I'm fully aware of the procedures that could follow thereafter.
Can you remind me, after how long is the head of court required to report that failure to deliver a judgment timely? Well,
now we have a system whereby the reserve lists automatically are forwarded to the Office of the Chief Justice. The administrative staff are doing that automatically. So the moment the 3-month period, that comes to the attention of the Office of the Chief Justice as they are prepared, these lists. So the moment any of those reserves are outstanding for longer than 3 months, it's up to the Office of the Chief Justice to take the matter further. But of course, that doesn't mean our Judge President and the Deputy Judge President is caught snapping. They are, in fact, encouraging judges weekly at our weekly meetings to actually ensure that their names are off that reserve list and that they deliver their judgments within those 3 months. So I would say 3 months is effectively the cut-off period.
No, I'm interested in that answer because what if the Office of the Chief Justice does nothing?
Well, that is why I say our team is not caught napping. Our Judge President and Deputy Judge President, in fact, is alive to the fact that judgments ought to be delivered within 3 months. Hence, we are reminded in meetings weekly about that. The list is circulated, and we are actually. It's pointed out to us that people have judgments outstanding.
I'm sorry to interrupt you. I just want to know, you have now sent the list to the Office of the Chief Justice, but nothing happens. 6 months go past, and what are you required to do?
No, of course.
Or are you suggesting that the Office of the Chief Justice should initiate whatever needs to be done?
No. Like I said, we would consult the colleague and find out what the problem is, but if the problem is not capable of being resolved, then the Judge President's office would report it to as an issue that needs further discussion at the JSC.
Reported to the Judicial Conduct Committee?
Yes.
Yes. So you know that the head of the court has that responsibility?
Yes, the head of the court definitely has that responsibility.
Yes, thank you. Judge President Lope?
Thank you, President. I have one question for the candidate. Judge Allie, if you are successful, what value will you add to the office of the Judge President? Thank you.
All right. The office of the Judge President, in fact, obviously has the same constitutional imperative as does the JSC itself, and that is to ensure that the judiciary reflects broadly the racial and gender representativity of the country. To the extent that we are now 39% women judges in the division, it is in fact heartening, but still insufficient. So to the extent that I could be of assistance in ensuring that we create or that we facilitate the bringing into the judiciary of more women judges, and particularly women to act as judges. Obviously, in consultation with, one would need to consult the profession. So I believe if I was in the office of the chief judge, if I was in the office of the judge president, I would in fact support that office by meeting with women lawyers organizations and lawyers organizations generally to see how we could improve the representativity of the judiciary as far as gender goes. There are several women lawyers organizations that spring to mind that one could meet with.
Can I just ask a follow-up question, President? Are there any weaknesses, Judge Allie, that you have identified in the system, in particular, how the Western Cape High Court is being run? Are there any weaknesses?
Yes, there's always room for improvement. I think with regard to, as I've indicated earlier, with regard to case flow management, we're doing very well. Statistics speaks for itself, but I do believe that we could streamline the pre-trial procedures even further, and we should be meeting and looking at how we can do that. With regard to the criminal matters that we receive, that we get, there is a situation where sometimes we're still receiving far too many criminal matters that could in fact be dealt with at regional court level. So there's definitely room for improvement there, obviously in consultation with the National Prosecuting Authority to ensure that those matters are in fact dealt with at regional court level. There's also the aspect, now that I'm on the issue of criminal cases, of the Section 105 capital A matters, the plea and sentence agreement issues. I know the Judge President himself has been recently engaging with the National Prosecuting Authority and others to ensure that initiative is streamlined so that we don't have a situation where matters are allocated to judges despite the pre-trial procedure and then the plea and sentence agreements are, come up at the last minute because it effectively is a waste of resources. And of course, to ensure more judicial oversight in those plea and sentence agreements. So that is an area that certainly can be improved on. And of course, when it comes to the enhancing and promoting of more gender representativity, as I've indicated, there's certainly a need for a woman deputy judge president who can be more receptive and more responsive to the needs of women judges and aspirant women judges.
Thank you.
Before I ask the representative of the Premier, I've heard other candidates for positions of DJP saying, this is what I think should be improved, this is what I think should be improved. But have you ever, in the judges' meetings, for instance, raised this with either the Deputy Judge President or the JP to say, you know what, I know that we are doing all right, but I think we can improve here. Can't we do this? Can't we do this? Can't we do that?
Yes, in fact, we're probably some of the most robust judges' meetings ever. We often have judges raising issues and they are taken forward. And we also have once a term, towards the end of the term, we have a full-on judges meeting where issues of concern concerning practice in the division, issues of concern are raised, and a lot of these issues are raised at those meetings. As I've indicated, we have very robust and vigorous debates in our division.
Thank you. Ms. Stewart?
Thank you. Judge Allie, my perception in the litigation I've been involved in is that the state has taken on a transformation agenda in the cases it runs through the Office of the State Attorney. But that agenda hasn't been assumed by private business to the same extent as the state. And I want to know if you've got the same perception.
Well, I've probably not been involved in sufficient matters of that nature to be able to give an informed, make an informed decision on that. But certainly, private sector. You're obviously referring to the briefs that you're referring to the members of the profession that the private sector briefs. Indeed, it is an issue with regard to the gender transformation. We and the judiciary can do our bit in terms of, obviously, when women in the profession avail themselves for acting positions, we do the mentoring, we do the skill sharing, we do the training, we provide the support. But ultimately, it is for the profession and its clients, including the private sector, to be on board with this and to ensure that there is a better distribution, for want of a better word, of work to women lawyers in the profession so that they can gain skills and exposure in areas such as commerce and other areas that they've been previously excluded from. But that is something that the profession should be dealing with their clients in the private sector.
Yes, thank you. Minister?
Judge Allie, good afternoon.
Good afternoon.
The Western Cape Bar is one of the least representative in terms of gender and race in the country. For example, I think if my figures are still correct, less than 20 of the over 400 advocates are African. Now, the pool from which to source judges that bars provide is a critical source. Would you agree?
Yes, the pool is critical, but we no longer, and indeed they should be broadening the pool. More, the conditions at the bar and at the sidebar should be improved so that more women can, in fact, sustain themselves in practice. But in addition to that, we are no longer restricted to in fact, drawing acting judges from the bar. As you know, we may draw acting judges from the magistracy, we may draw acting judges from academia, and we can draw acting judges from the sidebar. And indeed, there are more women in those professions whom we have been drawing. And to the extent, and let's be honest, to the extent that the Western Cape used to be regarded as a coloured labour preference area, we have a situation where not many African black practitioners have been able to, in fact, succeed in the Western Cape. That is regrettable. It's a situation that obviously needs to be addressed, not something that we as the bench can necessarily address, but there is nothing stopping us from bringing in African black candidates from other provinces, and indeed that is what we have done. That's what our Judge President has done, and I fully support that initiative.
What do you think, though, alienates African and women practitioners from joining that bar in your own
Well,
observation? You may
ye-
not longer be a member of the bar per se, but I'm sure as a judge sitting very close to the action, you should have your own observations.
Yes. Let me first correct you. I was never a member of the bar. I'm a member of the side. I was a member of the sidebar.
Okay.
But yes, indeed, the conditions that prevail at the bar, firstly, economically, it's hard for members who do not have the financial resources to sustain themselves initially at the bar. They have to effectively take chambers in blue chip company buildings. The costs are prohibitive. They have to sustain themselves for long periods of time before they receive briefs that are sufficiently remunerative. Regrettably, it's still a situation where they, as I've indicated earlier, do not receive briefs in the areas of work which are more remunerative and more challenging. That needs to be addressed, and I understand that the Legal Practice Act is in some way meant to address that as well.
Yes. Now, obviously, you as a sitting judge observe the teams of practitioners that appear before you and how they composed or constituted. Do you see inclination on the part of senior practitioners towards tagging along women, especially African women, Africans in general, and other categories of black, so as to empower them to transfer skills, so that they become more attractive to clients, be it public or private clients, towards them?
I must say, speaking for myself, from my experience in the 12 and a bit years, they are very far and few between. They are so far and few between that they are noticeable. You can actually immediately notice when you have an African black junior legal practitioner being taken along in a brief and being mentored in court. Very far and few between. Not nearly enough, I'd say. They have a long way to go in terms of sharing skills. Yes.
And just lastly, in relation to silk, again, the same challenge, also as a result of the pool being very thin. Do you think that nonetheless the judiciary should play a role in the recommendations that are made to the president as to who should be accorded silk? And if so, specifically, how do you think the judiciary, or what role do you believe the judiciary should play in the selection of candidates for silk?
Yes, thank you for that question. I, in fact, was called upon to make such an input once in the division, and I, in fact, declined for the following reasons. There is, to my mind, there has been no objective criteria developed for the judiciary to make such an input. If the judiciary does so, it will be on a very ad hoc and rather subjective basis. It will effectively be the perceptions of advocates that individual judges have based on the performance of particular advocates in particular matters. So, to my mind, that doesn't endear itself to me as a very fair and objective process. So I have grave reservations about the judiciary making comments on who ought and ought not to be given silk status. In fact, I think the bar itself has some way to go in terms of establishing its criteria more clearly. And in fact, and it ought to be taking account of its skewed briefing patterns, because if you say that members of the bar deserve silk status because of the nature and complexity of the work they engage in, then one ignores the skewed briefing patterns.
But just very last one. The intention is to actually develop such criteria. Do you think the judiciary should be invited to give input as the president perhaps works on
Give
the kind
input.
of criteria that would assist him in?
Sorry, is the question input as to the development of criteria?
As to the criteria themselves, in other words, the development of the policy, overarching policy framework.
Well, to the extent that the judiciary may have some comment to make as to the structure of the bar and the way it operates, most certainly there would be no harm in the judiciary giving input to the criteria.
Thank you very much,
So
President.
your difficulty is the judiciary being involved in promoting or not promoting a particular candidate.
Yes, in the absence of any criteria, and then, of course, it's very subjective because there's no standard test that is applied.
Thank you. Judge President Khomo.
Judge Ali, I'm going to be taking a particular line. As you know, I represent on this body the judges' president and also in some way the judiciary, apart from the Chief Justice, of course, and the President of the Supreme Court of Appeal. You understand that?
Yes, yes, Judge President.
Now, I just want to inquire from you whether you remember some interchange of emails between yourself and Professor Mutala on the judicial norms and standards.
Is that the question?
Yes.
Yes, all right. Yes, I do indeed. In fact, it commenced with text messages. Professor Mutala and I at the time were social friends, and he gave me what he called a heads up. So there were text messages that went between us, and later it was emails, yes.
Yes. Now,
I'd like to, though, say something about that right up front, if I may. May I, or would you like to ask the next question first?
yes, the chairperson said, yes, please do.
Okay, I unreservedly apologize to anybody who is offended by the WhatsApps. I accept that the content and tone thereof was inappropriate, but it is important for me to explain the context in which it occurred. I'd like to know if I may go ahead and explain the context.
Yes, you may.
All right? I asked the professors.
Just give me a moment.
No, I first want to hear from the chairperson will take this up from a particular point, but if you can just indicate to the JSC where in this exchange or the correspondence did you apologize? You have
No.
apologized now,
Yes.
but I just want you to
Okay.
refer us in the documents, the emails before us where you apologize.
Yes. I did not apologize in the emails or the WhatsApps. I considered that to be private communication between friends, and I called upon the professor at the time not to make it public. But to the extent that he has now recently made it public to this forum, and there is obviously now a need, since it's become now a public information, for me to apologize. So I'm apologizing now. Can I go ahead and explain the context?
No, the context will come. Of course, this is precisely where we are getting to. But I want to give you a fair chance. It has happened previously with two candidates. Before we put to them certain things that may be adverse, we inquired from them whether, having considered all that has gone into what we know, what is before us, whether they would still want to continue, because once you agree that we continue, it's in the public domain, then you must know that you bear the consequences. You're confident that you want to continue?
Yes.
Yes.
I'd like to continue, if you don't mind, to just explain the context.
Yes,
of
please
it.
do.
All right. I asked, as I said earlier, the professor not to make the texts public because it was private communications. But since he made it publicly, and I have to deal with it. The disclosure that he made public, though, I find to be an unconscionable breach of trust and confidence between two friends. The text messages that went between the professor and I was part of a robust and heated debate because he launched an unfair attack on the judges in our division and accused us of racism. His comments, in my view, were ill-informed because he did not know that our objections to the first draft of the norms and standards and our criticisms at the time were the result of a consultative process among all judges in the division, and the final, or rather our initial objections and criticisms, it was embodied in a document which we handed to the Chief Justice in a meeting in which we debated it with the Chief Justice. In fact, it was the decision of the division with the exclusion of certain judges who were heads of court or acting heads of court who are in our division. So it was the decision of the majority of judges in our division. So the professor was not aware clearly of this fact. And his criticism singled out one judge and then accused the entire division of racism. So to my mind, that was in fact an ill-informed and an unwarranted and unjustified attack on the division. And I told him, and I repeated here, that things I said to him I wouldn't say to someone else, because I trusted him as a friend, and he breached that trust. Because it was the discussions we had was part of our robust way of communicating with one another. We had, over the past few years prior to that, communicated with one another in messages, excuse me, over a whole host of issues affecting the profession, affecting the judiciary, affecting even legal academia. And up until then, all of those communications had remained private and personal communications. I didn't think that this would be any different. But of course, the lessons that I've learned is, like many people, I realize now that I should not communicate in text messages, even in personal even in personal communications.
Yes. Okay, then we proceed. This happened from the 19th of February 2014. Is that correct?
That seems to be correct. I don't have the exact date, but if that's what it says in the text message, then that would be correct.
Okay, I think in fairness to you, through you, Chairperson, can
No, I can have a look. I may have it if I may page to it. I can.
well, if they give it to you, then it would mean we have them in the same order, but you can still look at your.
Yes. Okay, thank you.
Let's
That's correct, Judge President Homo. It is from the communication started on the 19th of February, yes.
Yes, and that's more than 2 years ago.
That's correct.
And you say, if we look at the second paragraph, and I'll just read it, after the greeting, you say, I'm one of the et al., speaking to Professor Mutala now, I'm one of the et al., as you no doubt know. It was a fully consultative process and represents the unanimous view of the Western Cape Division. That's what's written. Have I read correctly?
That's correct, Judge President.
But from what you have just said, that can't be correct, because
Yes.
you said it excluded the heads of court, which means that, if I'm right, and you must correct me and this August House, this would not be correct then, because the heads of court and the Judge President would not have been present. I mean, you have said so yourself. So.
Yes, it excluded in our division we have judges who are heads of other courts. We have an acting head of the Land Claims Court. At the time we had an acting head of another court, if I'm not mistaken, the Free State Court. We had head of a labour appeal court, we have a head of a competition appeal court, so it excluded those judges. Because they were not present in the division at the time to be part of the debate. So yes, not every single word in the communications between myself and the professor is 100% correct. So indeed, I'm not nailing my colours to the mast and saying that every single word is correct.
So it's wrong, isn't it, to convey to Professor Mutala in some way that even the Judge President is part of what was decided here, because, as you say now, the Judge President was not part of their decision. It's not a unanimous view of the Western Cape.
No, it was not the unanimous view of the Western Cape, but it did include our Deputy Judge President and our Judge President, not the Judge Presidents and Deputy Judge President of other courts who happen to be sitting in our courts.
Yes. And then I want to read the last sentence in that paragraph. You say, I drafted most of the responses with minimal input from Grisel, because it seems that Professor Mutala had mentioned Grisel.
Yes, in fact, he had chosen one name, as I indicated, above all others as for criticism, and what I was trying to convey in the sloppiness of the late hour in a very short text message, which obviously is not as long as an email, was that I had a huge amount of input, more input into the drafting of the document, but of course not sole input. As I've indicated, it became a consultative process. I was one of the draftspersons. It then was circulated to all colleagues who gave the inputs. In fact, if you look at the document itself, you would see quotations from various colleagues in the document. So we actually quote some colleagues verbatim in the document. So it was an input. Obviously, I took responsibility as the primary draftsperson, but I'm not saying I'm the sole draftsperson. And I just felt that it was unfair for him to single out one judge's name and then go on a unfair criticism based on an allegation of racism, as though we, the rest of the judges, would be led by one judge and allow him to make alleged racist criticisms and objections without us having any input or say. That was my difficulty with the criticisms that he was leveling in the media.
Yes. Now, that part that I read to you of the WhatsApp was at 11:50 p.m. and at 12. And this is an aspect that I want you to look at. That's the third paragraph. The first sentence reads, "The committee that so proudly drafted the original norms and standards comprise Nathan Erasmus, an apartheid-era
Apparatchik, yes.
Okay, Apparatchik, thank you very much. Stephen Majid, a previous NADEL member who's now compromised his independence for personal gain, and Chris Govender, who overtly supported Binsworth's appointment at the JSC. Now, let's break this up a bit. Are you saying Judge Erasmus, Nathan Erasmus, who I know is more senior than you, is an apartheid, that word is going to trouble me a lot. Apparatchik.
Yes.
Are you saying that and you stand by that?
No, that is why I asked if before I could deal with the context, I first apologize, because as I've said, that in the heat, it was a heated and robust exchange, and I was obviously angry and felt betrayed by a person I considered a friend who appeared to share my values, my goals, who was making unfair and unjustified criticisms. And so in the heat of the moment, I made these comments, hence I apologized for offending people with those comments. I'm not defending the comments and saying that I stand by them or that I still hold those comments. In fact, when it comes to Judge Erasmus, he and I work collegially together, and he has been very supportive of me.
Yes. Noting that you're applying here to be second in charge, and this is a leadership position, so that there should not be any misunderstanding. Share with us what you mean by an apartheid apparatus.
Well, it basically means somebody who worked in the judicial system or in the justice system at a time when apartheid laws had to be implemented. It was part of the conditions of service.
And Stephen Majid is the second judge that you referred to, a previous NADEL member who's now compromised in his independence for the personal gain. Now, Stephen Majid is a judge of the Supreme Court of Appeal, isn't it?
That's correct.
At the time that you wrote this, was he already in the Supreme Court of Appeal, or was he still a judge of the Northern Cape?
I can't say. My memory fails me as to where he was then, Judge President. But like I said, I apologize for offending those people, and those comments were made in the context of a heated debate.
Yes, okay.
President Mpati, we want to follow, man. We are not following. Where do we go here? Which page?
Oh, sorry. No, I said it's WhatsApp and paragraph 3. Okay. Or page 3. Okay, sorry. It's not paginated. Let's see. 1, 2,
Pages
3.
4.
Yeah. Oh.
Have you got it, Commissioner Malema?